Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
Welcome back into the Outlaw Lawyers. Josh Whitaker and Joe Hamer, your hosts. You can find them at Whitaker and Hamer Law Firm. They're the managing partners there, practicing attorneys here in North Carolina. Offices conveniently located in Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, and Gastonia. Our special guest in studio, Cassandra Nicholas, also an attorney with Whitaker and Hamer. I'm Morgan Patrick, consumer advocate, and we start with a listener question.
So one of the good things about this show is that we try to encourage our listeners to call in. I talk to a lot of our listeners, try to give them a little bit of direction. Obviously, if the firm can help them, certainly let them know that. But if there's any general advice I can give to get one of our listeners going in the right directions, I always try to do that. And so I did talk to a listener or two the past week or so, and again, I like to take some of these fact patterns because if it's bothering a listener, if it's something a listener's having to deal with, I assume there's probably other people that have to deal with the same situation. So I like to kind of take names out of it, change up the facts, and just use these as listener questions that we can talk about on the show to see if our discussion might aid some others. So we have a listener question today, and the way I phrase this is my longtime partner. I'm using the word partner because in this situation, our fact pattern, well, we've got two folks living together. They were not married, so we don't have a married couple here. So I've got my longtime partner passed away unexpectedly. My partner did not have a will, did not have an estate plan. I can't access their accounts anymore, and they had a car in just their name. What should I do? And so in our fact pattern here, we have we'll just say we have a boyfriend and a girlfriend who have cohabitated, lived together for a long time, shared expenses, mortgages, bills, but had accounts in their sole name, had vehicles in their sole name, right? So they hadn't joined the household together. And here we have no estate plan. And so in our fact pattern, our person posing this question to us, they need access to these accounts, and in theory, going to have to get the car retitled or what have you. Cassandra works on a lot of estate. We'd call this estate administration, right? If we do some estate planning before you pass away, help you with your will, that's helping you estate plan. Once you're gone, though, we work with your heirs on estate administration, right? Putting that plan into effect. And Cassandra helps us a lot at the firm with estate administration. This person comes to you, Cassandra. What do you got for him?
Well, not the greatest news.
Right.
It is a difficult spot because an unmarried partner doesn't necessarily have legal standing as far as intestacy goes in North Carolina. So heirs of a person would first be their children. So if their partner had any children, those are the legal heirs. If they did not have children but do have one or both living parents, then the parents are the living heirs. If they don't have living children or parents, then their siblings are the living heirs. And then it goes out further than that if you still don't have any of those blood relations. So you'd first have to determine who the actual living heirs are, and hopefully this longtime partner gets along with whoever that is, because the legal heirs are really in the driver's seat when it comes to dealing with estate administration in an intestacy situation where there's not a will, is what intestacy.
Right. Yeah, so Cassandra's using a lot of fancy legal words. She sounds much lawyery than me and Joseph. But yeah, so when you pass away and you have a will, you have an estate plan. What's the legal word there? When you have a will,
intestate. With a will is testate.
Right.
Intestate is without.
That's right. You die when you pass away, you die without an estate plan, without a will. It's intestacy. And so if you die with a will, then we just look at your will, right? We go down to the courthouse and say, hey, Josh didn't make it. He fell off a zip line in an unfortunate zip lining accident. And he wants everything to go to his wife. He wants some things in trust for his kids. He wants to make sure his best friend from kindergarten, gets his original Nintendo, whatever it may be. The will just tells us, and everybody's fine with that. We don't care about the laws of North Carolina the intestacy doesn't come in. We're just going to follow the instructions in your will. Now, if there's something wrong in the will, you've left something to someone who's died, then who's not alive, we got to do some statute reading and figure out what's going to happen. But you can direct your estate any way you want to in your will. Here, of course, we didn't have a will, so we're stuck with what the laws of North Carolina say should happen. And in defense of the intestacy laws, their object is trying to get things to your natural heirs, right? So in the absence of a will, North Carolina wants things to go to your kids if you have kids. Of course, your spouse is in there if you're married. If they're not around, then it's going to go back up to your parents if they're around. If not, it's going to go to siblings. But the law, in the absence of a will, in the absence of your estate plan, it's going to try to get things to where most people maybe would want them to go. But yeah, if you are cohabitating, not married, there's no common law marriage in North Carolina. There's nothing like that. So you're not in a good spot. So the person asking this question, we don't have a lot of good news for them. And I made a note here, renouncing doesn't really work, right? So even if let's say in this situation, there's a brother and a sister, right? We don't have any kids. Parents aren't alive. There's a brother and a sister. Even if they don't want the stuff, right? Even if they don't want to be heirs, them renouncing doesn't get it to the partner. They're really in charge of this, and they're going to have to be involved, I guess, is the easiest way to say it. Yeah,
essentially. They can renounce their right to be the administrator if an estate does need to be opened with the county clerk. But even then, that just gives the longtime partner the opportunity to kind of handle the things, but it doesn't get like a bank account into the hands of the long-term partner to use as they want or need. So there are two issues. It's the bank accounts and the vehicles. Vehicles in North Carolina, if they are kind of a lower value, if they're under $5,000 of value, you can get a DMV form and transfer ownership of those without having to open an estate at all. Mm-hmm. It would still have to be to an heir. So
right.
Whoever that heir is would then get it into their name and then sign it back over to the partner if they choose to do so.
I think there's maybe some people still hold this view that where you have to have a lot of stuff to justify the time or maybe the expense of having an estate plan, having a will. But that's not the case. If you pass away and you've got a car and you got some bank accounts, even if your estate's not $3 million or whatever it may be, your heirs who may depend on you are going to have some trouble getting to that stuff if an estate plan's not in place. And so there's a lot of things you can do. There's a lot of things to think about. And obviously the more assets you have, the more people who depend on you, the more important it is to have an estate plan. Because once you're gone, you may not be around to worry about it. But your family, your heirs, again, the people that depend on you are going to have a tough time. We're going to have to come sit down with me or Cassandra or Joseph and try to figure out, all right, what's the easiest way to proceed at this point and to get things to where they need to go. But here, an estate plan would have prevented this. No one expects to pass away unexpectedly. But it's just something you get to a certain age. It's just something you gotta take care of because it can be difficult.
And in the alternative to a will, or in addition to a will even, you can avoid having to open an estate with a county clerk by having someone else's name on all of your assets. So if this vehicle that we're discussing had already been owned jointly, if there were two names on the title, joint with right of survivorship, nothing needs to be done at all. It is automatically owned by the other person on the title at the passing of the first person. Same with the bank accounts. If they had added someone jointly on those accounts, those automatically pass without anything else needing to be done. So setting up your loved ones for the least inconvenience possible is a really kind thing to do in your life.
And in my old age, I think about that. Anytime we've been trying to buy a car for a while, they're hard to find right now. But anytime you buy something, getting it titled in you and your spouse, or you and your partner's name, or you and a child's name, like when you do set up bank accounts, making sure they have, payable on death beneficiaries, or they're jointly held. There's a lot of things you can do without sitting down with an attorney to try to, like you said, Cassandra, to try to make it easier when that time does come. But this is an example of a tough spot to be in, and not a lot of good advice to give after the fact, but definitely a learning experience that maybe others can benefit from.
The Outlaw Lawyers, Josh Whitaker and Joe Hamer, Whitaker and Hamer Law Firm, where you can find them. They're the managing partners there, practicing attorneys here in North Carolina. Our special guest in studio, Cassandra Nicholas, also an attorney at Whitaker and Hamer. They have offices conveniently located in Raleigh, Garner, Clayton, Goldsboro, Fuquay, Varina, and Gastonia. If you've got a legal situation you are facing, you've got questions, give us a call, 800-659-1186. That's 800-659-1186. Leave your contact info, briefly what that call's about, and an attorney with Whitaker and Hamer will be in touch. And you can always email your questions to the program. That's questions@theoutlawlawyer.com, and we'll answer those on a future program. And always check out the website, theoutlawlawyer.com. We're back to wrap this one up right after this.